We know that landlord-tenant matters are generally governed by state law, but what about if the federal government is the landlord? Does that change things? The Southern District of New York tackles this question in the 1998 case of United States of America versus Epstein. In 1992, the federal government leased a Manhattan building to Jeffrey Epstein. The lease stipulated that the premises could be occupied only by Epstein, his family, servants, or approved assignees or subtenants. The lease's assignment and sublease clause required Epstein to obtain the government's prior written consent for any assignments or subleases. No language prohibiting the government from unreasonably withholding such consent was included in the lease. Epstein used the property as a residence for himself and his family until 1996, when he subleased it to Ivan Fisher without the government's written consent. Fisher in turn sublet part of the property to several subtenants. As a result, the government terminated Epstein's lease and brought an action in district court to eject Epstein, Fisher, and Fisher's subtenants from the property. Epstein and Fisher contended that Epstein tried to obtain consent for the subleases, but the government withheld it unreasonably because it had a more profitable leasing opportunity. The government, therefore, they claimed, violated an implied covenant of good faith and fair dealing. The government asserted that it was entitled to arbitrarily withhold consent under New York law and moved for summary judgment on the issue of ejectment.